All right, we are live. Welcome, everybody. I'm Leonard French, your favorite copyright attorney, here to report on your other favorite copyright attorney, Richard P. Liebowitz, who has been suspended in a way. And so this is not going to be, it's not a half... There's no catch to this story. He really has been suspended, but how we get there is the catch. He's not been directly suspended the way that you think that an attorney would normally be suspended for sanctionable conduct or misconduct or a violation of his rules of professionalism or ethics or whatever. So we're going to get to how he got suspended, and it's kind of a ride. It's not going to take that long to get there. It's only a 10-page order, so I'm going to go over a couple things. Richard Liebowitz, of course, is everybody's other favorite copyright attorney because he's always in the news for having violated some court order or some rule of procedure or some rule of ethics, and he's always getting sanctioned, or he's getting an attorney's fees award that he has to pay as opposed to the client has to pay, or sometimes his conduct results in the client having to pay the attorney's fee. And so he's had, I think, we've made 38 videos, and I think there's even a longer list of misconduct that Judge Jesse Furman has put together that I'm going to show you in a moment. So what has happened now is this announcement. I first saw it from Booth Suite, which is, I think, Dan Booth and Jason Sweet. I think I'm getting their names right and not getting them reversed, saying the Southern District of New York, Richard Leibowitz's home court, has just suspended him from practicing law. Goliath Cleric, thank you for the $2. Is there any chance he will not be disbarred? He's probably going to get suspended at least, but this is not that. We are talking about the federal district court. The Southern District of New York is a federal district court, and of course that is where you practice copyright, so that's a big deal for him. This is not some shoehorned story. We're not burying the lead here, but an attorney's license is licensed by the Supreme Court or the highest court of a state, which in New York is not the Supreme Court, it's the lowest court. It's weird. But the state of New York gives him his law license. That's not what we're talking about here. This is the Southern District of New York, the federal district court that has suspended him from practicing law. And it's not going to be in the way that you think. So let's go through it and see what's going on here. So we are in the Arthur Usherson case. And this is Arthur Usherson versus Bandshell Artist Management. This is Judge Jesse Furman. We've talked about this before. Judge Furman is going to do a summary, and then I'll break into what Judge Furman is referring to. So Judge Jesse M. Furman, United States District Judge for the Southern District of New York, issued a memorandum opinion order today on June 26th. So back a few months ago, the court issued a 54-page opinion and order, familiarity with which is assumed, and we did a video on it, so eventually when this is a VOD, I'll try to put a bubble up there for you, imposing a range of monetary and non-monetary sanctions on plaintiff's counsel, Richard Liebowitz, and his firm, the Liebowitz Law Firm, and then he gives a citation to Usherson v. Bandshell Artist Management, a previous order. To the extent relevant here, the opinion and order there required Mr. Liebowitz and his firm, 1, no later than July 27th, to serve a copy of the entire opinion and order, quote, on every one of the firm's current clients, and for Mr. Liebowitz to file a declaration attesting to such service via the electronic filing system. And 2, no later than July 27th, to file a copy of the opinion and order on the docket of any currently pending case that was brought by Mr. Liebowitz or his firm, and for Mr. Liebowitz to file a declaration attesting to the same on the electronic filing system. And 3, to file a copy of the opinion and order on the docket in any action that is filed in the future within 1 year. So there's a lot to unpack there. So let's see what's there. First, I have some fun facts for you. I looked up some things using one of my research systems. Liebowitz has filed 2,329 federal lawsuits, or he's appearance counsel in 2,329 federal lawsuits. He's only been licensed since 2015. So that's a lot of lawsuits. That is, let's see here, that is 2,329 times a $400 federal court filing fee. That's $931,600 just in filing fees alone. And you can imagine now he might get some kind of money, some kind of funds from settling those cases. I would say maybe we can assume a majority of the cases result in settlement. There's lots of cases that he's gotten in trouble with, but not certainly 2,329. So some large majority of those cases likely resulted either in settlement or voluntary dismissal of the case. So he's probably earned himself and his clients a rather large sum of money in the 5 years or 4.5 years that he's been practicing. 2,027 of those cases are closed, so we can assume that there was some resolution to them. That doesn't say what the resolution is. I would have to do a lot more research to figure out exactly how it breaks down. There are still 302 active cases, and 112 of those are active in the Southern District of New York, where he's now suspended. So he will have to withdraw, or I'm not even sure how that works. I guess he has to file a notice of withdrawal, because in the federal court system, you don't automatically withdraw. You have to file something to get the court's permission. I don't think that any court is going to deny his withdrawal, since he is not practicing, since he's not admitted to the SDNY court system and he has now been suspended from it. So I think he is going to have to withdraw from 112 cases. Now, funny, if you notice on here, it says the court issued this 54-page opinion and order on June 26th. Well, it turns out that on June 25th, 2020, was the last time Liebowitz filed a new case in the Southern District of New York. So interesting timing there. I bet you he knew something was coming. However, he is still actively, up until November 17th, just 2 weeks ago, he was still filing federal lawsuits in other districts. I think the latest one was in the Northern District of Oklahoma, of all places. And so then if we go over to that opinion and order, the one from the one from June 26th, this is where Judge Furman really roasts Liebowitz, and we're not going to go over this at all, but I am going to scroll all the way down here to the judge's appendix, which is attached here. Not his medical appendix, but rather a reference of all the cases that Liebowitz has filed. And so there's pages and pages and pages of all the different cases where Liebowitz has been either sanctioned or disciplined or having to cover fees and costs. And I think we counted 40 the last time I saw this. And indeed, yeah, there are 40 cases where Liebowitz has been sanctioned or disciplined or had to pay fees and costs because of some kind of misconduct, or something was wrong in those 40 cases. And really, I'm not going to go through all of those now. Maybe we'll finish with that. Let's continue here, though. So that 54-page opinion with the appendix had to be filed on court dockets in all of those cases. On July 27th, 2020, which was the due date, following the denial by this court of Mr. Leibowitz's request for a stay of the opinion and order pending appeal, as well as the Second Circuit's denial of his request for an immediate stay. I don't know if you remember that one. I think he petitioned the Second Circuit Court of Appeals a little bit late. I think it was like on the eve of the due date, and so the court was like, you can take your chances with the Second Circuit. You know, they're not going to grant an immediate stay with 1 day's notice or a couple days' notice. But the judge goes on. Mr. Liebowitz filed a declaration attesting that he had served by email a copy of the order on every one of the Liebowitz law firm clients identified in an Liebowitz law firm internal email list, which he had reviewed for accuracy and, to the best of his knowledge, believed to be complete. We're already kind of getting there with the cop-out language, huh? And 2, filed a copy of the court's order on the docket of all currently pending cases brought by him or Liebowitz law firm. Mr. Liebowitz further attested that he identified all currently pending cases brought by him by searching on Pacer in every federal judicial district around the country for his name as counsel of record, which is not really the way that you're supposed to do that. The Pacer, case locator, and the individual district court search engines aren't really as powerful as the research tools that we pay for. So I have 3 research tools that I pay for. One is through Jenkins Law Library, and I have access to Fastcase through that. That's a normal thing when you don't want to pay for Westlaw and Lexis, which are a couple $100 a month. Then I have Docket Navigator is something new that I'm using now, which is about $50 a month, and that is how I can easily search all of Leibowitz's cases. And then we also pay for Law 360, which I don't know if I'm allowed to disclose what my deal is there, but somewhere around $2,000 a year is what I pay for that. And so these are expensive, and I'm not getting the impression that Liebowitz, who is searching for himself on Pacer, is really then paying for a legal research system. I really hope he is, because you kind of need that. You also need an accounting system and customer relationship management system and all sorts of organizational tools when you have 2,329 cases that you filed. So maybe we're starting to see what's going on there. So he searches all of that, and by relying on his firm's internal records as well, for the small number of cases filed by Liebowitz in which he is not counsel of record, okay, so he has some cases where he is using local counsel instead, and then he double-checked these filings using his internal case management system, whatever that is. Notwithstanding these representations Judge speaking now, notwithstanding these representations, on September 21st and 29th, so just a few months ago, Liebowitz filed declarations with this court identifying cases brought by him or his firm in which he had neglected to file the order and only belatedly complied with its requirements. The court also received communications from third parties concerning Mr. Leibowitz's compliance, or lack thereof, with the court's opinion and order. In light of these developments, the court ordered Mr. Liebowitz to file a sworn declaration that explains, notwithstanding the process described in the declaration of July 27th, how he overlooked the cases that his firm conceitedly described in the declarations of September 21st and 29th, and describes what steps, if any, he has taken, and when, or what steps he will take to identify any other such cases, and describes with particularity. So we recently did the case on what is fraud. Fraud requires you to plead with particularity. That means you go through all the steps, every single step of how you get there. We're not accusing him of fraud. We're saying that, like fraud, he has to plead with particularity the steps he took. How the LLF internal email list used to identify the clients to whom he provided the opinion and order was compiled, who is responsible for maintaining it, how and how often it is updated, whether it is possible there are any clients, or whether his firm would not be on that list, of clients of the firm would not be on that list, and if so, describe what steps he's taken, when, and what steps he will take to identify such. So he's identifying all the clients that he may have missed, and then responds to a letter addressed to the court by a third party, July 28th, by identifying whether there are any cases in which he or his firm is acting as counsel in any way but has not entered a formal appearance, as of the date of the order, if so, showing cause why he should not be treated as in violation. So that's an order to show cause why you should not be held in violation, and in any sense showing cause why the opinion and order should not be modified to require its filing in any case that his firm is involved in, whether or not he has entered a notice of appearance. On October 15th, Mr. Liebowitz filed that declaration in accordance with the court's order. Astonishingly, he identifies 113 cases. 113 cases in which he was required or arguably required to file the opinion and order at issue here, but nevertheless failed to do so. That list includes 12 cases that Liebowitz says he missed because he did not search the districts in which the cases are pending, or simply missed the case in the list generated by Pacer somehow. 5 cases that Pacer listed as closed, but still had motions pending for which he subsequently realized he should have filed the June 26th order. 62 cases that were pending as of the date of the June 26th order, but were not pending as of July 27th because such cases had been settled, dismissed, or terminated in a default judgment between June 26th and 27th, so some cases that were in between there. 18 cases in which Mr. Liebowitz believed he was no longer counsel of record and therefore not required by the June 26th order to file such an order, but for which he subsequently recognized that filing was required. 11 cases in which he had not entered a formal appearance or lacked filing credentials, so lacked the permission to file. 5 cases that are connected to the firm because the firm has a retainer agreement with the client and Liebowitz law firm likely discovered the infringement, but for which neither Liebowitz nor Liebowitz firm initiated the case, neither him nor the firm entered a notice of appearance, and the case is being handled by a third-party lawyer. There is strong argument that further sanctions against Mr. Liebowitz are appropriate. Oh, and there's a footnote here. This list does not include cases that were identified in previous communications with the court in which Mr. Liebowitz should have, but nevertheless failed to file the opinion and order, and then they give a list here. There is strong argument that further sanctions against Mr. Liebowitz are appropriate in light of these myriad failures to comply with the court's June 26th opinion and order imposing sanctions. Had Mr. Liebowitz failed to file the opinion and order in a handful of cases, the failure to comply might have been understandable and excusable. But the failure to file it in 113 cases is astonishing and suggests contumaciousness, an egregiously disorganized case management system, or both. It is all the more astonishing in light of Mr. Leibowitz's record set forth in painstaking detail in the court's opinion and order and his repeated representations to the judges in this district and beyond that he had taken steps to improve his case management practices. That said, the ultimate purpose of sanctions is deterrence. And, as Mr. Leibowitz's extraordinary record of both sanctions and non-compliance with court orders demonstrates, it is far from clear that there is any additional sanction that would serve to deter him. Moreover, on November 30th, so I don't know if you heard that, but the judge is sort of giving up right there and saying, I don't know what else I can do to you. But, moreover, on November 30th, 2020, which was literally yesterday, 6 hours ago for me and 18 minutes ago for some of you, this court's Grievance Committee, noting Mr. Leibowitz's repeated disregard for orders from this court and his unwillingness to change despite 19 formal sanctions and scores of other admonishments and warnings from judges across the country, entered an amended order immediately suspending Mr. Leibowitz from the practice of law before this court, pending final adjudication of the charges against him. Thus, for the time being, there will be nothing to deter when it comes to Mr. Liebowitz. So Judge Jesse Furman is basically letting him off the hook of any sanctions that Judge Furman can visit against him because the Grievance Committee took it out of his hands. Accordingly, the judge says, and in light of the Grievance Committee's order of November 25th, which I guess is, there's two parts to that or something, the court, exercising its discretion, determines that additional sanctions are not appropriate at this time. That said, and for the avoidance of any doubt, the court concludes that its currently applicable non-monetary sanctions should be modified to make unambiguous that they apply to any case in which Mr. Liebowitz or the firm is involved as counsel, even if Mr. Liebowitz or the firm is not counsel of record. Thus, this court orders as follows. In any action involving Liebowitz or his firm that is filed between the date of this memorandum opinion and June 26th, between the date of this memorandum and June 26, 2021, Mr. Liebowitz or his firm shall file a copy of this opinion and order on the docket of the case within 2 days of filing the complaint or otherwise initiating the case. In any action involving Mr. Liebowitz or the firm that is filed between the date of this memorandum of opinion and order and June 26, 2021, that involves allegations or claims of copyright infringement, the complaint shall include, as an attached exhibit, a copy of the deposit files maintained by the U.S. Copyright Office, because that was a thing in one of the cases. I think that was a thing in this case, the Usherson-Banshell Entertainment case. In the foregoing paragraphs, any action involving Mr. Liebowitz or the firm means any action in which Mr. Liebowitz or the firm enter a notice of appearance, any action in which Mr. Liebowitz or the firm are involved as counsel, even if neither has filed a notice of appearance or otherwise appeared in the action. Finally, the court will send a copy of this memorandum, opinion, and order to the chair of the court's grievance committee to take whatever action the court deems appropriate, and that's Jesse Furman, United States District Judge. Now, let's take a moment here, because there are lots of you here. I want to say thank you to a couple of you. Thank you to Ammonite for the $2 Canadian. Time to pop the champagne. Kyle Epstein, thank you for the $5. What else could he do that he hasn't already done to finally be disbarred? He could be accused of mishandling client money, or he could be accused of dishonesty. I had to think of how I was going to say that with a straight face, because he's already been accused of dishonesty, right? But dishonesty with the court, dishonesty with client money, or mishandling client money are usually the fastest ways for an attorney to get disbarred. Dawangai, $5, thank you. Non-monetary sanctions, hence from my court. Okay, so get out of my courtroom. And then Dustin C., thank you for the $5 Canadian. I'm surprised that a judge hasn't blown their appendix with Liebowitz. Yeah, right? So that's not all. That's not where we are done with this yet. There is then attached Exhibit A, which is the Grievance Committee's decision. Let's see what's in here. So this is in the matter of Richard Liebowitz. Thank you for the $5, Alt Grendel. Good news, everybody. And this is an amended order, so I think that's the November 25th was the initial order, and November 30th yesterday was the amended order. And I could not find this on the court's website, so I'm glad that Judge Furman attached it to his order so that we could all see it. This matter comes before the Committee on Grievances for the Southern District of New York, the committee, to consider the imposition of discipline against Respondent Richard Liebowitz, Respondent, based upon charges brought against him by the committee on August 5th, 2020. So if you're wondering how long it took the Grievance Committee to get around to it, I'm not really knocking the Grievance Committee, maybe a little bit, because it should have happened a long time ago, right? I was there a year ago for Judge Kathy C. Bell's interrogation of Liebowitz over the my father, grandfather died thing. And that really should have been a time that the Grievance Committee started to get involved. And so it took until August to stop his shenaniganery. So August 5th, to which respondent responded September 25th. So we did speculate that maybe he was in the background getting some sort of disciplinary action and he was going to have to respond to it. So we know now that he was responding to it. Given the current status of the investigation as confidential, So the investigation is not public and we don't know what the charges are. Both the charges and the investigation underlying their imposition are both referenced without detail in this order. The full committee, consisting of Chief Judge McMahon, Judges Castell, Daniels, Nathan, Stanton, Viscosal, Magistrate Judges Aaron, Cott, and McCarthy, and the undersigned as chair, we'll see who that is at the end, has now reviewed respondents' submission as well as the record developed during the committee's investigation. After careful deliberation, the committee is unanimously of the view that the charges are strongly supported by the record. So we don't know what the charges are. We can make some guesses. We're going to look at that list in a moment. But the committee, there wasn't one person of the 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 people on the grievance committee. There wasn't anybody who thought, hey, maybe these charges aren't warranted. So it was unanimous. What is more, the committee is unanimously of the view that interim disciplinary measures against respondent must be put into place immediately. The preliminary remedy of an interim suspension is available to the committee in situations where it is appropriate to protect the public from future disciplinary violations of a respondent during the pendency of proceedings before this committee. The record in this case, which includes respondent's repeated disregard for orders from this court and his unwillingness to change despite 19 formal sanctions. So that's where Judge Furman got that language from. And scores of other admonishments and warnings from judges across the country leads the committee to the view that recurrence is highly likely. In short, in light of the nature and seriousness of the charges, the strength of the record supporting those charges, and the risk and danger of reoccurrence, the committee concludes that an interim suspension of respondent from the practice of law before this court, so it's just SDNY, pending final adjudication of the charges against him is warranted. In the exercise of its discretion, the committee will defer the final adjudication of the charges against respondent currently pending before this committee, as well as any other charges this committee sees fit to bring against respondent in the future as part of these disciplinary proceedings, until after respondent has had the opportunity to present his defense to the charges at an evidentiary hearing before a magistrate judge of this court. So Liebowitz will get a chance to defend himself. It's probably going to be a private chance to defend himself because the judges don't seem to be willing, understandably so, to present the charges to the public yet. And that's usually how these disciplinary proceedings go. We usually find out once the charges are decided or once an adjudication has been made, then we find out what the decision was. Accordingly, for the reasons set forth above, respondent is hereby suspended from practicing law in the Southern District of New York, effective the date hereof. I guess that's November 30th, but it was also back to November 25th, pending the outcome of these proceedings and until further order of this court. It is further ordered that respondent is commanded to cease and desist and refrain from the practice of law in the Southern District of New York in any form, as principal or agent, clerk, or employee of another, that respondent is forbidden to appear as an attorney or counselor of law before any judge or court in the Southern District of New York, that respondent is forbidden to give an opinion as to the law or its application or advice in relation to any matter in the Southern District of New York, all effective date hereof, until such time as disciplinary matters pending before the committee have been concluded, and until further order of this court. So that is an indefinite suspension. Not, and this is amazing, not just the practice of law before the court, but also any opinion as to the law or its application or advice in relating to any matter in the Southern District of New York. So that means no copyright cases, no copyright consultation. He can't be employed by another attorney as even a clerk or employee at all He is 100% forbidden from doing any copyright work or any legal work or practice whatsoever before the federal district court for the Southern District of New York. That is about as bad as I think it can get. This court does not have jurisdiction to disbar him, so I don't expect that we're going to see him get disbarred by the Southern District of New York. We will see him get suspended or disbarred in the sense that they will take away his right to practice in the federal district court. I do expect that, but I don't think we'll actually see him lose his license to practice law. He would then have to return to practicing state of New York law and whatever other federal district courts still allow him to practice. So he recently filed this Northern District of Oklahoma case. Maybe the Northern District of Oklahoma doesn't have a problem with him yet. So who knows what happens there. But I have a feeling that this is not the end of the beginning, but rather the beginning of the end for Richard Liebowitz. So yeah, so then I thought, let's take a look here at these 40 entries. We didn't read through these last time, so let's just try and get through some of these and see how interesting they are. This is the appendix to that June 26 order in Usherson v. Banshell Entertainment. And so the judge gives a bunch of cases. Sadowski versus Ziff Davis. Liebowitz regularly fails to comply with court orders and has been repeatedly sanctioned as a factor weighing in favor of requiring a bond. So this court required a bond, which is money to cover fees and costs in the future. While one can always hope that Liebowitz will comply with court orders in this case and conform his behavior to the standards of his chosen profession, it is difficult to be sanguine on the score given his track record. So that's not quite disciplinary action, but they required a bond. So then we have Inri Richard Liebowitz in California, finding that Mr. Liebowitz has falsely held himself out as a member of this court's bar on multiple occasions, even though he has never been a member, noting that his unprofessional and blameworthy conduct is consistent with the extensive public record of discipline he has amassed in courts around the United States, and concluding that there are good grounds for doubting that Liebowitz should be permitted to practice even on a pro hoc vice basis, which means entering your appearance for that case only, kind of like my cousin Vinny did in that story. Romalis versus Alexander Wang. Declaration in support of sanctions, stating that opposing counsel repeatedly requested licensing history from Mr. Liebowitz, who first claimed that he could not retrieve it without a subpoena. Then he admitted that there was no licensing history, so licensing as in the copyright license, at which point he filed a notice of settlement and avoided adjudication of the sanctions motion. Geertz versus San Francisco Bayview, denying Mr. Leibowitz's admission for pro hoc vice in a case filed in the Northern District of California, I'm guessing, NDCal, 1 day after he was disbarred in the case above. Polaris Images versus Entech. The court could not award attorney's fees against Leibowitz's client because Mr. Liebowitz had filed a notice of voluntary dismissal before the court ruled on the motion to dismiss. The court sympathizes with the defendant and their frustration with plaintiff's conduct and is only too aware of the notoriety of plaintiff's counsel, Liebowitz. Alvarado versus Mother Jones, denying Leibowitz's motion to appear pro hoc vice, finding that he continues to regularly file and litigate cases in the Northern District of California following his order of disbarment. Wow. Mondragon versus Nasrak LLC, concluding that Leibowitz's continued practice of law represents a clear and present danger to the fair and efficient administration of justice. Chevrest versus Barstool Sports, sanctioning Liebowitz under Rule 16 and finding that his attempt to plead administrative oversight was disingenuous, distasteful, unpersuasive, likely perjury, noting that he filed 25 new cases during the time he was allegedly prevented from complying with the court's order to timely file proof of service. Ward v. Consequence Holdings, concluding that Liebowitz likely filed this action as a bad faith, frivolous effort to harass the defendant, imposed $20,000 in sanctions. Wisser v. Vox Media, I think we went over that one. Imposing sanctions for various discovery violations, including affixing his client's signature to interrogatory responses without authorization and without the client having even read the responses. Massey versus Mythical Entertainment, dismissing the case without prejudice for failure to comply with court orders because Mr. Liebowitz's refusal to cure a litany of filing deficiencies which mirrored numerous deficiencies in other cases. Durmansky versus Telephonic Media, I think, citing Leibowitz's misleading conduct, cherry-picking few cases that support his maximum statutory damage award while ignoring the numerous contrary case law, warning him that he may be subject to Rule 11 sanctions. Rock v. Enfant Richer de Prime, I think we covered that one as well, granting attorney's fees against Liebowitz totaling over $100,000, $10,000 of which Mr. Liebowitz and his firm were responsible for sanctions. Otto versus Hearst Communications, denying an award for attorney's fees because he and his client consistently and undeniably asserted inflated values for the copyright, wholly unsupported by the evidentiary record. Caravani versus Nooklin, affirming magistrate judge's decision to require Liebowitz to post bond, where plaintiff's attorney's fees been ordered to post bond, previously sanctioned for misconduct. Okay. Sands v. Bauer Media Group, dismissing an action with prejudice because Leibowitz's client's failure to post a bond to cover costs and attorney's fees. Liebowitz stated falsely under penalty of perjury that his client did not make a settlement demand in that case, even though he plainly did at both the initial conference and in an email for Mr. Liebowitz. Wow. Berger v. Imagina Consulting, holding Mr. Liebowitz in contempt of court, imposing sanctions of $500 per day that he failed to comply with the court's orders, and ordering Liebowitz to appear and show cause on pain of arrest by the United States Marshal Service. This was the one with Judge Kathy C. Bell, in connection with Mr. Leibowitz's misrepresentation about the date on which his grandfather passed away, in which he made in order to justify missing a discovery conference, and then his refusal to provide documentation regarding such. The lawyers have a duty of candor to the tribunal, so that means that you're supposed to be forthcoming. You're not supposed to hide things from the court. The court will actually treat you better if you admit you made a mistake than if you lie about it. Believe it or not. I know that Liebowitz is an outlier here, but believe it or not, that's supposed to be something that happens. Polaris Images v. CBS, imposing sanctions under Rule 16, concluding that given the frequency with which Mr. Liebowitz commits administrative errors, the undersigned is unconvinced that they are indeed good faith oversights, and noting Mr. Leibowitz's continual regard for the court's orders in multiple other cases. Real quick here. Oh wow, there's a bunch of you. Tom Losh, $5, thank you. Just because this video makes me smile. Fallen AK, $5. God dang, finally action on this dude. Goliath Cleric, $5. What does this mean for Liebowitz in the myriad other districts he files in? He's going to have to file the court's opinion and order, and the judge attached the disbarment notice or the suspension notice, so the other courts are going to be notified, at least in theory, that he is suspended. Lehigh Kitten approves of this video. Rudolph Bescherer, thank you, $5. Godless Melanesia, Unicorn, $1.49, thank you. OPT Lawyer, Leonard, did you ever think this saga would get this crazy after your video about Liebowitz lying about the death of his grandfather back in November of 2019? I didn't think it was going to get this crazy back then either. I mean, I drove to White Plains, New York, and suffered through several hours of waiting for the case because it was interesting. I never thought that any, I mean, okay, let's go back a second. I represent clients who are accused of internet piracy, and I've had 2 clients so far that have recidivated. It's the wrong word for it. I think that's more of a criminal law word, but 2 clients who knew that they had been caught and they had been there had been a settlement. I can't say how much, but there had been a settlement not necessarily in their favor, and still went on to do the thing again. So I know that, and I was still very surprised that Liebowitz would do it again and again and again and again. He has a golden goose. He's built this tremendous practice, filing 2,329 lawsuits. All he had to do was manage it, hire people to help him manage it, and not make all these mistakes. I mean, you have a Rule 1.1, so Rules of Professional Conduct, Rule 1.1, Duty of Competence, which implied in the Duty of Competence is that you don't take on more cases than you can handle. So he had an ethical duty this whole time that he's supposed to know about. In order to take the bar, and then in order to have a license, he has to have taken the Multi-State Professional Responsibility Examination, the MPRE. He's supposed to know his Rule 1.1 Duty of Competency, and so he violated that, and I really don't understand. Ronald Radecki, thank you, $5. Banish the troll. Rod, undefined Rod. I'm not a legal person. What is the requirement for filing an opinion? I had to close the pop-out to regain the super chat. Thank you for the $5. What is the requirement for filing an opinion? He would need to be admitted to the court, so he can't file opinions where he's not admitted. Filing the court's opinion. So I'm thinking of complaints. He's, in order to file the opinion, I think he has to file the opinion in all the cases that are now pending with Liebowitz law firm. And he's suspended, so there's not going to be any, right? I mean, that's basically, he hasn't filed an SDNY case since June 25th, so he really, I think he's only got to file these things in new cases. Star Foreman, $3. That's a cool emoji. It looks like a fall guy. Cool. Gabriel Bad Wolf, 499 pounds. I'm surprised he's not been forbidden to even be a janitor for a law firm. Yeah, well, technically he has. He's not even allowed to be an employee. I don't think that means that he's not allowed to be only a lawyer employee. He's not allowed to be any employee of a law firm. Stuart Tamanaha, the same emoji of the fall guy looking thing. $4.99. Thank you. BSC, $5. Given his record of ignoring sanctions, suspension, disbarment, what are the odds Mr. Liebowitz continues to file an SDNY anyways? He'll technically still have access to do so. As far as I know, this doesn't remove his electronic filing access, so we could actually see that kind of violation. Katrina Middleton, $5. About blanking time. Thank you. The Platypus, Australian, $7.99. Can the other courts use this as justification to keep him out? Yes. Whenever you pro hoc vice into a court, you have to certify that you don't have any disciplinary action, and if you do have it, you have to explain it. So he would have to explain it, otherwise he'd be in further violation. We did see that one, Ohio case where the judge was just like, okay, you kept violating my orders, whatever, just get out of here, and didn't seem to do anything to him. So that was anticlimactic. Then we have Inri Liebowitz in Northern District of California, October 7th, 2019, ordering him removed from the membership roll of the bar of the court after he filed a case without being an active member of the state bar and submitted an explanation that he was not responsive and... the court submitted an explanation that he was not responsive and does not say anything at all about his membership of the State Bar of California. So he tried to file without following the pro hoc vice procedure. Crane v. Stylish Curves, sanctioning Liebowitz for failing to appear at an initial status conference or request an entry of default as ordered by the court, noting that he made no effort to even contact the court until more than a week after the deadline had passed. And after rescheduling the status conference, directing Liebowitz to attend this conference personally, not to send some other lawyer. Mango v. Democracy Now!, concluding the history of Leibowitz's failure to comply with court orders, counsels in favor of the imposition of additional bond. So not all of these are sanctions, some of these are just bonds. Rice v. NBC Universal, imposing $8,745.50 in sanctions under the court's inherent authority plus Rule 16, finding that Leibowitz's disobedience of the court orders, both the orders requiring mediation and Leibowitz's appearance on May 2nd, was willful. Craig v. UMG Recordings, holding Liebowitz and his firm jointly and severally liable for the attorney's fees of $98,532.62. This was the no go after with Mr. Craig, I believe. And reaffirming the court's inference that Liebowitz acted in bad faith. Stelzer v. Lead Stories, granting dismissal with prejudice as a sanction for repeated failures to comply with deadline and court orders, including a scheduled conference, noting that plaintiff's counsel has previously been sanctioned in another district. Rice v. Musée Lingerie, noting that plaintiff's attorney Liebowitz has previously been sanctioned and ordering imposition of a bond. Stridiron versus Community Broads something. I forget what the abbreviation Broads means. Broads? No, I don't know. Noting that, like in the present matter, Mr. Liebowitz has regularly been found to have failed to comply with court orders, and courts in the Southern and East District of New York have now begun to regularly require plaintiffs represented by Liebowitz to file bonds. 1 second. Lee versus W Architecture and Landscape, relying on counsel's history of violating court orders to impose a bond. Dveer versus Dancing Astronaut. Mr. Liebowitz failed to comply with the court's order, and he must be suspended for 18 months in the hopes of deterring future noncompliance. Where was this? So VEC is Valerie Caproni, imposing sanctions communicated to him in person, face-to-face, by the undersigned to be suspended. Oh, the sanctions were suspended. He wasn't suspended. The sanctions were suspended. Okay. So I guess that means that the sanctions were then imposed. Otto v. Hearst Communications. Recor Entertainment, thank you for the $5. Is there any way this affects a lawyer other than Liebowitz and his firm? Can other Liebowitz firm lawyers get in trouble for practicing law after this? No. I think they can't. That's a good question about the firm, though. If Liebowitz is the principal, the owner of the firm, can another lawyer continue in his stead? Yes, the lawyer would be then operating on their own, I think, because without Leibowitz's name, you cannot continue to call the firm the Liebowitz Law Firm. This is a thing. This is an ethical thing with attorneys and law firms. Usually, if the attorney is suspended or disbarred, I think you can't continue the firm under that name. I think it might vary from place to place, and I don't exactly remember that rule of ethics. But there was definitely something in my ethical training that if you sell a law firm, then you can't necessarily keep the name, but then there are some ways that you could keep the name. I think I'm going to have to just say that I don't know on that one for sure. And Rodent, no last name. Thank you for the $5. Keep fighting the good fight. Would you consider taking a peek at the Kent Hovind suit? He's suing the Fed for $500 million. Okay, that sounds like it's going to be unsuccessful on its face, but I will make a note of it. Thank you. Otto versus Hearst Communications, again, concluding that sanctions were not warranted on the current record, but it's a close call. This is hardly the first time the firm has had their reputation called into question. Pereira versus Canada, 3072541 Canada Inc., finding that Liebowitz failed to follow the court's orders and rules in at least 3 ways and declining to impose monetary sanctions, but expressing concern over repeated failures to follow the rules of the court. McDermott v. Monday, denying Leibowitz's request to redact the term copyright troll from an opinion that described him as such, because there's evidence of the astonishing volume of cases coupled with an astonishing rate of voluntary dismissals and quick settlements. Undisputed that Mr. Liebowitz is a copyright troll. So I guess we can actually call him a copyright troll because the court did. Ferdman versus CBS. Plaintiff, represented by Liebowitz, has offered no explanation for his failure to produce copyright application-related materials. So this is going backwards in time, and we're getting earlier or later and later from this date and earlier in time. Seidman v. Gax Productions, sanctioning Liebowitz for serving unsigned interrogatory responses even after this court reminded him to do so. Liebowitz versus Galore Media, ordering Leibowitz's client to post bond in part because defendant has a justified concern that plaintiff's counsel will evade court orders and voluntarily dismiss the action in an attempt to make plaintiff's assets unreachable in the case. I guess that was a different Liebowitz as the plaintiff in that case. Romanowitz versus Alistair and Payne, imposing monetary sanctions after Liebowitz failed to attend the inquest hearing as ordered and failed to request an adjournment. Terry versus Masterpiece Advertising Design, rejecting Leibowitz's argument that the court should award $20,000 in damages without conducting any inquest as to having no basis in law and being constructed of whole cloth. So no basis in case law. And he repeated it as part of a second motion. Steger versus JMS Cleaning Services, imposing monetary sanctions and a requirement that Liebowitz complete 4 CLE hours in ethics and professionalism in an effort to address Leibowitz's pattern of omissions and misrepresentations, and noting that even Leibowitz's motions for reconsideration of the sanctions order continues the pattern. Reynolds v. Hearst Communications, we're seeing a pattern there with a bunch of those. Liebowitz also argues that plaintiff has not willfully disobeyed court orders, obstructed discovery, or increased the cost of litigation. This is demonstrably false. Liebowitz failed to comply with orders, as he had with other lawsuits. He failed to include the campaign to which the plaintiff had voluntarily given the photograph at issue. So that was a license of some kind, which then passed the photograph along to defendant as part of his suit, or even to mention the plaintiff's relationship with the campaign. Janik versus SMG Media, concluding that the Liebowitz law firm made a total hash of discovery requiring multiple court conferences, and there was a failure of counsel to adequately communicate and coordinate with the plaintiffs, let alone with opposing counsel in the court, and warning that Liebowitz law firm needs to consider its reputation with the court and frankly clean up its act. And Konangata versus American Broadcasting Companies. Broadcasting is what that means, yeah. Granting attorney's fees to Mr. Leibowitz's adversary because no reasonable lawyer with any familiarity of the law of copyright could have thought that the use of the work at issue was anything but a fair use, and noting that defendants may pursue claims of professional misconduct on the part of plaintiff's attorney before the appropriate disciplinary body. That was back in SDNY in 2017. So yeah, that's what it's what he's suspended from. The further practice of law in the Southern District of New York in any form as principal or agent, clerk, or employee of another. I guess, you know what, maybe it's from the practice of law in any form, either as principal, agent, clerk, employee. So yeah, maybe he can still be a janitor at a law firm. I probably got that wrong. Respondent is forbidden to appear as attorney or counselor before any judge or court in SDNY, forbidden to give an opinion as to the law or its application, or advice in relation thereto, for any matter in the Southern District of New York, all effective, the date hereof, indefinitely, until such time as disciplinary matters pending before the committee have been concluded and until further order of this court. I am sure that we will have more follow-up for you when we get to the actual suspension or imposition of those charges, because we don't know what those charges are yet. We can guess. It's probably all of what we just read in those 40 things, all summarized into one probably very long legal document, which we will enjoy bringing to you here on Lawful Masses. Of course, this is where I end the show. Thank you very much for coming. I'm Leonard French, your favorite copyright attorney, your favorite clean record copyright attorney, and this is Lawful Masses, your favorite legal news and education program here on YouTube. We are also on Floatplane, and we do a Sunday show on Twitch, which is our production show. Thank you for our community supporters, including the Super Chats today, but our community supporters support us on a monthly basis on patreon.com/ljfrench, on sponsors.com/law, by joining YouTube membership or by joining Floatplane membership. We really appreciate you all. At the $50 level for the month of November, today is the last day for the month of November, and then tomorrow we'll have the month of December. Joe Tyson, West Delj, this is thank you to Joe Tyson, West Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Andy, Benjamin Hitov, Goliath Cleric, Ugly Grill, Shielo T, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, Hot Grills in Your Area, Brandyn Abel, Torpedan, Cassandra Curran, Mayor of Titty City, ShadowTycho, RDHDragon, Earthbound Star, and no copyright violation intended. My LED panel is showing all of the $5 plus supporters, and normally we would have a crawl here and a little outro, so I'm just doing that manually here on the live stream. So I've been wearing this hat the whole time. This is the Wicked Witch of the West hat because ding dong, the witch is dead. And this might be the beginning, this should be, hopefully is, fingers crossed, this is the beginning of the end for Richard Liebowitz. So let me see if we have anything else to say before I let you go. I hope you all have a good day. Thank you, S, for the $2. And we'll see you in the videos that drop. Longreach Jones, Australian $5. Thank you for the news and the Liebowitz entertainment. I'll add this to the list of Liebowitz videos. This will make our 39th Liebowitz video. So yeah, thank you for coming. I love you all. Have a great day. Bye.